I'm Michael Dolan, the Acting Manager of the Law Institute Ethics Department. I've had many years' experience in both country and city legal practice, as well as in the corporate sector. Welcome today to our LIVing Ethics panel discussion, where we'll spend an hour with 4 experts discussing the ethical issues which arise out of several real-life scenarios solicitors face in daily practice, and I will moderate the session. Let me introduce to you our distinguished panel of experts. On my immediate left, Nicole Ryan-Green, who's Special Counsel at Clayton Utz, where she practices in commercial litigation and teaches ethics. On my far left, Danny Barlow, who is a Director of Riordan Legal in Shepparton and Yarrawonga, a former Law Institute President and a current member of the LIV Ethics Committee. On my far right, Bob Galbally, a founding partner of Galbally Rolfe Criminal Lawyers and a foundation member of the LIV Criminal Law Committee. And on my immediate right, Nahum Mushin, who is an adjunct professor of law at Monash University, where he teaches ethics to law students. Nahum served as a judge of the Family Court of Australia for 21 years. The LIV is very grateful to our panel of experts for contributing their time and considerable experience without charge in the interest of assisting LIV members to maintain the highest standards of ethical behaviour in their daily practice of the law. Fred is a sole practitioner in a country town. For the past 6 years, Fred has acted for a company which owns a number of parcels of residential land. Fred's role has been to act for the company in conveyancing matters as land has been progressively sold. There are 3 shareholders in the company, each of whom are directors. The directors consist of 2 brothers and the son of one of the brothers. Fred has never acted for any of the directors personally. A situation has arisen where it is alleged that one of the brothers has misappropriated substantial funds from the company for his own use. The other brother and his son approach Fred and ask him for advice regarding what action they can take in respect of the first brother. Can Fred act for them? Let's ask Danny Barlow. You're a country practitioner, Danny, and this is the kind of situation which often arises in the country, doesn't it?
It certainly does. That's something that we'd see very regularly in a typical country practice. My feeling about a scenario is that it's probably better to take a cautious approach. I think that one could make an argument that there is a distinction between acting for the company and the directors, and there might be some merit in that argument, but in a practical sense, I don't think the directors of that company would quite see it that way. I think that they go to the lawyer and think that they are getting advice from that lawyer, and they don't draw the distinction in their head necessarily about whether that advice is for them or the company. And I think they might feel a little aggrieved if they then found that that same lawyer who they'd put some trust in was then acting against their interests. And it's also, of course, possible they might have disclosed some things during those meetings, even simple things like their attitude to litigation. You often hear a director of a company say, look, there's no way I'd go to court. I would never do it. I'd always settle. And that could be really important information, and it shouldn't be used against the person.
Nicole, as special counsel in a major Melbourne law firm, you must trip across conflict of interest situations quite often.
Absolutely. I think I agree with Danny. There is a potential technical argument here to the extent that are the directors coming to you to ask for advice on behalf of the company, or are they coming to you to ask for advice on their behalf personally? And I think it does depend on that. I do agree with Danny, though, that there is a certain perception in this, not just for the directors in this particular case, but for all directors. I think if we as a profession uniformly stood on the technicality of, well, I was acting for the company, I wasn't acting for the directors, therefore I'm entitled to effectively take up the cudgels against directors, I just wonder whether that would undermine the candour and the honesty that we try to have with our clients and with our instructors on behalf of a company. I mean, the practical reality is we get our instructions to represent a company from our directors. That is the practical reality. And as Danny says, I don't think they would appreciate the technical distinction that we could then turn against them.
We can be very good at, can't we, talking about the corporate veil, but the clients see right through the corporate veil.
The clients do, and also I think from a public perception, I always think as a general sort of flavour to impose across all of it, what would the reasonable person in the street think? Is this a good look? Does it make us look disloyal? I know that certainly had one been acting for the directors then it would be a simple open and shut case. Here, the directors are not former clients, but I still think it's something that I know comes up in a lot of the ethics presentations. If something feels a bit sneaky, if something feels a bit not right, that's probably enough to say, look, stop you right there before I give you any advice. Go and speak to somebody else. They've not invested anything in you so far.
Bob, criminal law has its own special brand, I guess, of conflicts of interest, but in this kind of situation over the years, I'm sure you've seen this situation with directors of companies and what you do. What do you think about this situation?
I'd like more facts.
Mm-hmm.
I'd like more facts because I'd want to know who was giving the instructions in the first place, and perhaps it might be possible, if the facts were right, to continue to act, but only if the facts were right. And I think here there might be a duty on you as the lawyer to either advise the company secretary or perhaps the older of the other brother,
mm-hmm.
the non-offending brother, to report it to the police. Now that involves a whole different scenario. Just imagine if the police are involved in an investigation about the misappropriation of the funds, you then have probably a prosecution, and a question's going to be asked as to who's going to be giving evidence on behalf of the company to prove the misappropriation of funds. So on the bare facts of this case, prima facie, there's a conflict,
Mm-hmm.
but I'd want to know more facts.
Sure. Nahum, over the years as a judge on the family court bench, I guess conflict of interest was something that often came to your attention. What do you think about this situation?
Well, Michael, the first thing is that the test of conflict of interest in family law and in other areas of the civil law are quite different. In family law, of course, what you're looking at is whether there's a theoretical risk, and at the point at which there's a theoretical risk of a conflict, then the onus shifts. In civil law, there's got to be really a real risk. To my mind, this is a relatively straightforward matter. With respect, I don't agree with Bob. In my view, one should follow what I regard as being a golden rule in conflicts. If you're in doubt, you get out, and that's the end of the discussion, to my mind. I think, however, it is open to Fred to suggest that all the parties obtain independent legal advice, and if they consent to Fred acting, then that's open. However, issues of consent always have difficulties about them, and it seems to me that on any view there's a significant similarity between the facts of this case and the decision of the Court of Appeal in 2001 in Spin Code, in which Justice Brooking delivered a judgment which is very highly regarded, to my mind, as well as that, as Justice Bill Gillard said many years ago, there are the getting to know you factors, and I think Danny referred to that. Those getting to know you factors, when you act for somebody, you know about them, you know what the buttons are that can be pushed, and that in itself is, in my view, a risk in terms of confidentiality, which I think is not worth taking.
Could I add, though,
Sure.
if there was a criminal prosecution that followed here, Fred would be hopelessly conflicted.
Oh, there's no question about that.
Yeah.
The only other thing I would like to mention as well, it may be playing devil's advocate a little bit, obviously these conflicts all boil down to a balancing exercise, because we don't want a situation where clients are limited in terms of who they can choose for their counsel, and also I think you need to consider the economic viability of legal practice for country solicitors. The availability of another solicitor to send somebody off to. If this happened in Melbourne, go down the street. If it happens in a country town where there may not be another lawyer for some distance, that's something that all needs to be balanced, because I don't see this as an open shut case. I think that there would be grounds here, certainly in New South Wales, which are a little bit stricter on these matters, to say that there wasn't a conflict. Given that the solicitor here has acted largely in conveyancing matters, I wonder whether there's a real danger of misuse of confidential information.
Mm-hmm.
I don't personally think there is necessarily a duty of loyalty given that it's not a client. My issue would be with the third ground of the spin code case, and that being the public perception that this is not a good way of going about this, that it detracts from the judicial system.
Okay.
Could I ask a
Sure.
question following on from
Please, Bob, yes.
that? What happens if the father, the non-offender, says to you as the solicitor, there's been these misappropriation of funds? Do you think there's an obligation on you to report it to the police or give you advice to go to the police?
What do you guys think about that,
Does
Danny?
a theft taken place?
So if the father, the non-offender, tells me of the alleged offences,
Misappropriation.
well, there's a tactical element to that, apart from anything else, from a commercial litigator's point of view, about whether that's a good or bad thing from the company's point of view, if you're at the point where you're acting for the company. But I just have to work through in my head, well, hang on, before I say anything in response to that, do I first work out whether I have a conflict or not? If I then decide I can act, well then I expect that would be advice you give to the father, depending on whether you thought it was in the interest of the company to do that or not. I don't think there would be an obligation to tell them to report it to the police.
This is where I think there is an issue of coming back to that, distinguishing whether these directors are seeking the advice on the basis of the company, on the basis of themselves personally. How does this solicitor continue to receive instructions from the director who's in the wrong here in relation to the company? Does he at all? There becomes a real difficulty with who he's accepting instructions from and in what capacity. And that's where it starts to get mucky. I think what we were saying over here, when it starts to feel doubtful, perhaps the better course is simply to remove yourself from the situation.
Yes, I agree with that, Nicole. My answer to Bob's question is no, the solicitor doesn't have an obligation to go to the police. The information is known to those who've got an interest in it, and it's open to them to go to the police if they see as being fit. But I don't think Fred's got an independent obligation in that regard.
We're at Edom.
Well, there you go.
I thought we might be.
What I think this scenario has really effectively demonstrated is that often there are no precisely black and white answers to ethical issues, and often it will depend on what the circumstances are, and does this apply or does that apply, and tactically what should you be doing, those kinds of issues. I think what we've heard around the table though is that when you get to conflict of interest, be very, very careful, because there can be potential disciplinary consequences there, and there can be consequences that may give rise to an action in professional negligence against you as a solicitor, and you don't want to be in either of those situations. So again, in the conflict situation, be very, very careful, and if you'd like an independent opinion on it, call us at the Law Institute Ethics Advice Line and we can talk to you about it. So thank you very much, Nicole and gentlemen, for that discussion. I think it was a very good discussion, and it brought out, I think, the salient features of this particular scenario, which very commonly occurs in legal practice, but particularly in the country. So Fred has been acting for Tim in several motor car traffic offences. Tim has been murdered recently. Some of Fred's letters to Tim have been found by members of Tim's family, who asked Fred to disclose to them the nature of the matters for which he was acting for the deceased. There is no intention to apply for probate or letters of administration. Tim's family are very distressed and are at a complete loss to understand why he was murdered. They've asked Fred if he can tell them about the matters in which he was acting for Tim, as they feel that this may throw some light on the reasons for his murder. Fred does not believe that the traffic offences have anything to do with Tim's murder. Fred would like to help, but feels that he's prevented from doing so by his duty of confidentiality to Tim, which he still owes despite the death of Tim. What can or should Fred do in these circumstances? Well, Bob, this is right up the criminal alley on this one, so what's your reaction to it?
I think the starting point is that the family are at a loss to understand why he's deceased, and are probably wondering whether there's a nexus between Fred acting in these traffic matters and his death. I think that Fred is entitled to release some information but he's prohibited from releasing any confidential communication by the deceased to him. I think he's entitled to say the case did not involve or did not raise any facts which might have been relevant to how he died. So there's no nexus between them. I think he's entitled to say, I'm banned from disclosing any confidential communication. If you want to know more about this, you could go to the court and get a copy of process that's filed with the court. You could also go to VicPol, Victoria Police, and do a FOI application and get a copy of the brief of evidence to see what facts were relied upon by the prosecution in the case. But that's about all I think Fred would be able to disclose.
Okay, Danny, if this had happened in the country and the relatives were coming to see you and you knew them and they're obviously very distressed and seeking some comfort, how would you feel about how you might handle this?
Well, I'd hope that I would do the right thing, and I think I would in the sense of realising that the duty of confidentiality still applied. That's the first thing. And I think this comes with experience a bit, and we try to impart this onto younger lawyers. Those difficult situations are the ones where you can often get yourself into trouble because you feel pressured either by the clients or even morally to do something that you really shouldn't quite do. So I wouldn't suggest that I would have thought of all the options that have been suggested, but if I couldn't find an answer, I think I would have rung someone like Bob, who perhaps would have known a bit more about the options available and found out those answers and relayed them to the client.
If you look at this practically, if Fred were to say to the family, I make an assessment, I can't tell you what it is that's happened, but in my opinion, what has previously happened has got nothing to do with it. I think that just compounds the problem for the family because they're simply going to want to know the basis on which Fred's made that judgment. Of course, if there were formal probate or letters of administration, the personal representative would be entitled to that information. And to my mind, although I understand how difficult it might be, particularly in the grief of the deceased's family, I think Fred should stick to the strict letter of the law and should not give out some information, because if you give out just a little bit, I think it just makes it more complicated.
But wouldn't you put a caveat on it and say, I am a lawyer and therefore I am bound by certain rules and I can give you certain information, but I'm prohibited from giving you some information? And if you need to consult another lawyer about it, you can, or, as I say, you could go to the court, or you could go to the police if you wanted to know more facts about it.
Bob, I'm not absolutely convinced that Fred wouldn't be unreasonably breaking confidentiality by giving even that much information. That's, I suppose, the difficulty that I have. I think it is arguable that even a statement which is derived from clearly confidential information might in itself be confidential. And so I think there's a risk which, to my mind, I don't think is worth taking.
What do you feel about that, Nicole?
I think it's harder for the family in a sense too to give them something, because in a way, whilst it's a harsh proposition and unfortunately these ethical conundrums sometimes come up in the context of very emotional scenarios, but I think if you say to them, I can't tell you anything, I have a duty of confidentiality, it's really sorry that I'm not able to give you the information that you seek, that's something they may or may not agree with, but it's a line in the sand position. Whereas I think if you sort of say to them, well, I can give you some information, I can tell you that I don't think that the matters in which I acted are relevant to his death, I just wonder whether it's a little tortuous, whereas they sort of think, well, you've bent the rules a little bit, maybe you could give me a little bit more.
Bend them a little bit more.
Yeah, and I think the other issue too is, what if you're wrong? It does seem inconceivable, but just imagine, for example, the traffic offences were committed whilst he was on his way to see a friend who was engaged in a criminal activity, or in some way these things are integrated. I totally sympathise with the desire to give some comfort to the family, but I do agree with Nahum here that I think it's very dangerous.
Okay.
Bob.
And if there was to be an inquest, then the family could seek leave to appear at that inquest and tease out
Absolutely.
whatever facts they want to tease out.
In terms of going to the police, though, I was wondering when we were talking about that, do the family even know that these matters were criminal? I just wonder, it seemed like such a good suggestion for them to go and get that information this way, but would it be feasible to say to the family the matters in respect to which I acted were criminal matters? I wonder whether that would be of assistance for them to then know that avenue was...
Except they weren't criminal matters, they were traffic matters. And that'll be revealed by the public record being the summons that's filed at the court.
Bob, you mentioned earlier on going to the police and seeking an FOI request for their file. Would there be also some room here, given that a murder has taken place and would no doubt be being investigated by the homicide squad, to perhaps speak to members of the homicide squad about it as the family, to see what assistance they might be able to give, because I presume they're not bound by the same rules of confidentiality as lawyers are?
No, they're not, and you would readily obtain audience with the homicide squad if you were a family member and you wanted the facts.
Mm-hmm.
My feeling of that is that there must be several practical ways in which you could pursue this without putting Fred at risk of disclosing confidential information.
I agree.
Begs the question then of what the lawyer says when the homicide squad come knocking and want information. That's a whole other Pandora's box.
Indeed, well, that opens the whole Pandora's box of legal professional privilege and, you know, what documents can and should be made available to the police, and if they are privileged, whether in fact it's then got to go to a court to have that issue of privilege determined. But yeah, that probably is a discussion for another day. Again, Nicole and gentlemen, I think it was a very useful discussion, and what it brought out to me, I think, particularly was this, that everyone, absolute agreement, we really feel for the family in this situation, and as a lawyer involved in the process, we'd like to do everything we can within our legal boundaries to help them. And I thought what came out of it was really the duty of confidentiality to a client is sacrosanct, but at the same time, we would like to think of some practical ways that we might be able to assist them in managing their grief for their deceased relative. So thank you very much. So Fred acts for Sally in a parenting dispute in the Federal Circuit Court. Pending trial, interim orders are in place allowing the child to live with Sally subject to constant supervision by her mother. Sally and her partner both have drug and alcohol issues. Sally's partner finds on her Facebook page photos of Sally and the child on holiday. Fred is asked by the other side to confirm that Sally's mother was present on the holiday. Fred seeks instructions and is told by Sally that her mother was present on the holiday and was the person who took the photos. Fred conveys this information to the other side and also to the independent children's lawyer. A week before trial, Sally tells Fred that she lied about the holiday, the mother was not present, Sally had breached the interim orders. In addition, Sally's mother had breached her formal undertakings to the Federal Circuit Court to supervise Sally. Sally apologises to Fred and asks him not to say anything to anyone. What, if anything, should Fred do? Well, Nahum, this is right in your former jurisdiction as a judge, a family court matter where a client has lied. How does the practitioner deal with this situation?
Well, I had this situation as a practitioner on a number of occasions. It's by no means unknown, this sort of thing, not just in family law, but it can be particularly serious in family law. Fred cannot divulge to the court what his instructions are. His advice to Sally needs to be, you either allow me to correct the record or I withdraw. And I think really there's no other alternative involved. But he cannot disclose those instructions because they're privileged and confidential, and to do so would be a very significant breach of ethics.
Okay. Bob, I guess lying clients are not unknown in the criminal jurisdiction either. So even though this is a family law matter, perhaps you could bring some of your extensive experience in that space to helping us resolve it for the solicitor.
Well, this example is probably a good illustration of why I didn't do family law and decided not to. Yes, occasionally you do get a blatant lie from a client which puts you in an invidious ethical position, and thank God nowadays that we have the rules which are clearly stating what our ethical position is, because when I was an article clerk, these rules really didn't exist, or didn't exist in their current form. So they've obviously been built up over a long period of time with a lot of experience, and sometimes we use those in the criminal jurisdiction to work our way through it. Fortunately, the rules encompass both advocacy for solicitors who are doing appearance work in criminal law, as well as acting just as the solicitor and briefing counsel.
And Nicole, I guess in commercial litigation it also crops up from time to time.
Absolutely. But the interesting thing about this case, I think, is that unlike, and I was thinking more in the criminal context in that moment, unlike a situation where you have a client who may say to you, I did in fact commit the offence, and there is a very limited scope where you might decide that you can continue to act very carefully, and you would need to carve out your role in such a way that you are not misleading the court. But for example, you might ask the other side to make out the elements of the offence, or perhaps just put them on their proof. The problem here is the court now are currently harbouring under misapprehension that you need to either correct or get out. I agree with Nahum. I don't see that there is a middle ground here. I don't see that there is any possibility that Fred can continue to act. He must withdraw if Sally refuses to give those instructions to correct the record.
And do you agree with that, Danny?
Yeah, I do. I agree with everything that's been said on this subject. I do perhaps have one further observation, is that where I think it gets tricky in practice is where a client discloses to you that something they've, for example, said in evidence in a trial before a judgment's handed down was false, and they've realised, and often it was an inadvertent thing that they've said, but it's completely irrelevant to any issue in dispute between the parties. Now my view is in that situation, you don't call the court back to tell them that, well, the evidence was he ate a ham sandwich that day, but it was in fact a chicken sandwich, if it's got absolutely nothing to do with the issues between the parties. Now that's an extreme example, but the trickier ones where you've got to think about, well, does it really make any difference to anything? Do I make a fuss about this or not? This example is clearly a very serious one, but it's the borderline ones that I think really get difficult.
In family law, the duties which you have ethically, which start with the duty to obey the law, continue with the duty to obey the court, then the duty to your client, and then to others, has an extra gloss to it, because of the fact that family law proceedings are usually involve and very often are about children, so that there is an extra duty to the child. And in a circumstance such as this one, while I don't think these particular facts raise the issue, there can be circumstances in which your duty to the child can put you in conflict with your duty to your client, which might in fact lead to your forming a view that you should be discussing the matter at least obliquely with the counsel for the child, as you might imagine it, the independent children's lawyer. So that I think is a really important thing to bear in mind in family law. The ethics in family law are that much more complicated by virtue of that extra duty.
I mean, if we've got parents here who both have alcohol and drug problems,
yes,
and this child is being unsupervised or not supervised in the way that the court has dictated, that's a very real concern. Bob?
Yes.
And perhaps we should point out also, Michael, that this factual scenario falls within the ambit of Rule 15 of the rules, 15.1 in fact, but 15.2 does embrace the criminal jurisdiction.
Indeed, and that's the Professional Conduct and Practice Rules of 2005 to which Bob is referring. And of course we need to remember here in Victoria that those rules, whilst they've been in place since 2005, probably within the next year or so are going to be replaced by the Australian Solicitors Conduct Rules once the Legal Services Board finishes its formal approval process in respect of those rules. But the rule that Bob has been talking about is reflected also in the new rules as well. So I think it's been around for a long time and will continue to be around for a long time. I think that that issue of the children is a particularly important one that we need to keep in mind in all family law matters, Nahum. And again, bearing in mind that in some circumstances and on the ethics advice line, we sometimes get calls where it becomes apparent that the safety of the children might be at risk. And in those circumstances, of course, whilst we have a duty of confidentiality, one of the exceptions to that duty is that if we breach the duty of confidentiality for the sole purpose of preventing the commission of a serious criminal offence, then that is in fact an appropriate course that the solicitor may choose to take. And particularly I would have thought where children are involved, that's an exception we just need to keep at the back of our minds.
Well, for example, I made orders at times requiring lawyers to disclose the whereabouts of a child who was at risk. Those are things, that's a good illustration of the importance of the duty to the child.
Indeed. And the other thing that illustrates, if I may say so, at the end of the day, you've then made the lawyer's task very simple, because the lawyer has an overriding duty to the court. And once a judge of a court makes an order, then it's the lawyer's responsibility to carry out the terms of that order.
I think, Michael, that's probably one of the most, if not the most important message to come out of that whole scenario, that if you only ever remember one thing about ethics, I often say it's that paramount duty is to the court. However much you might owe a duty to your client and obviously act in the best interests of your client, at the end of the day, as officers of the court, your paramount duty is to the court and to be truthful with the court. So, and that's just something that runs through all of these a little bit, I think.
Nicole, thank you, because I think that really sums up that scenario and the discussion around it. A number of things were teased out around it, but I think we're all agreed that the rules are very clear on how the solicitor has to act in those circumstances, and also keep in mind the welfare of the children who are before the court, who are often the innocent victims in this kind of situation. But again, in all kinds of family law matters, lawyers are always having to undertake those kind of balancing acts, but within the context of their ethical responsibilities. A friend of yours is buying a house. She tells you that she needs some documents witnessed. You're assuming it does not include a solicitor's certificate and is just regular witnessing. The friend's parents also need to sign and have their signature witnessed by an Australian lawyer. They could be going guarantor, but you don't know for sure yet. The parents live overseas and the friend needs to have these documents completed and handed back to the bank in 4 days' time. The bank has told your friend that you could witness the signatures of the parents over Skype. You have met her parents once, years ago, and you would probably recognise them when you see them, but your memory of them is so hazy you could not describe them if you had to without seeing them first. So what should you do? Well, what an interesting one. Nicole, let's start with you on this.
I wouldn't do it. I don't like it. I know that there are people with a different view on this. I think there are identity requirements that are very difficult to satisfy remotely. That would be my first difficulty. Secondly, I'm just wondering about the control of the document once it's signed. So I guess there are procedures you could put in place, but if the person is signing a document and then somehow it's making its way back to you, how can you be certain that what comes back to you is the document that was actually signed? Off-screen influences, do we know who's in the wings pressuring or influencing the person? That concerns me. It seems to me that the Evidence Act requires documents to be witnessed in the presence of, for a very good reason. And my understanding of in the presence of means in the presence of. And I guess the only other thing for me, which is a little bit more sort of touchy-feely, but I think it's really important, when people are witnessing documents, particularly when they're witnessing affidavits, which are obviously sworn evidence, there's nothing wrong with it having a little bit of gravitas, for it having that solemnity of the proceedings. And I wonder whether we lose a little bit of that by doing it remotely. For example, I will tend not to joke around with clients or have a casual atmosphere when they're swearing an affidavit. I will tend to make it a very formal process to really underscore what they're doing here and the importance of what they're doing and being honest in their witnessing of documents. And I just feel that this is taking this a step too far if we're doing it remotely. It detracts from that process, I think, the proximity.
Interestingly enough, over the past several months, we actually have had several calls on the ethics advice line addressing this very situation. Danny, you're a member of the ethics committee and you have to deal with ethics situations on a regular basis in that committee. What was your feeling about this one?
I actually thought this one was fairly clear cut. I agree with Nicole. I wouldn't do it for a number of reasons, most of which she has put forward. The fact that a document is to be witnessed by an Australian lawyer to me suggests that that requirement has been put there because they want someone who can be trusted to do the right thing and make sure it is in fact that person that is signing that document in their presence. And I wouldn't take the risk, for all the reasons Nicole's put forward, of doing it any other way. And I certainly agree about there is some degree of solemnity in regard to those things. As a young lawyer in the magistrate's court, I got an awful tearing down from a magistrate because I whispered to someone in court while an oath was being taken. It was made very clear to me it was a serious thing that was happening, and I've never made the mistake again, I can tell you.
Well, let me tell you, that happened to me when I was an article clerk as well, Danny, except I didn't get the tearing up by the judge. I had a very charitable senior barrister who was sitting in court who just put his arm out on me as I was walking through the court and said, "Stop." And I didn't go any further, but he could obviously see that I might have copped a serve from the judge had I kept walking. So it's always good to learn these lessons, but fortunately in my case not the hard way. Nahum, what do you feel about it?
Well, first of all, I have to say that I have a vivid memory in the early 70s of copying such a serve from a judge, and it's one of those things one never forgets. That's the starting point. I essentially agree with what Nicole and Danny have said. The starting point for me is this. Does the law say that you can't do this? If the answer to that question is yes, that's the end of it. You don't need to think about anything else. The second point is, even if the law doesn't say that, or at least clearly, my gut tells me that you shouldn't do it. It just doesn't feel right. And I think going with your instincts on these sort of issues, on a lot of these issues, is a good way to start. However, if your gut doesn't warn you, and if the law doesn't say it can't be done, one would need, in my view, to put into place all sorts of protections. The first thing is you would need to make a statement of exactly how this is to be done. If it's to be done by Skype, is it to be done by licences being held up in front of a camera and documents being sent by fax or whatever. The next part of that would be that once you've got that scenario all worked out, you would get it absolutely clearly in writing from the bank. We will accept a document if this is done. The third thing then would be that the practitioner, having done that, would swear an affidavit or make a statutory declaration in which that letter would be annexed, and you would then say it's been done like that. Now, I can imagine it being done, but as I say, my bottom line is I think that Nicole and Danny are right. You just wouldn't do it.
Do you draw a distinction in between, say, affidavits and witnessing bank documents?
To my mind, affidavits are completely out of the question.
Yes.
In fact, I think VCAT's spoken on this quite clearly, hasn't it? And I think, in fact, not only VCAT, but I think the Supreme Court has as a result of at least one decision in VCAT, has spoken extremely clearly on it. As far as affidavits are concerned, complete no. You get a notary public to do it overseas, or consular official, or whoever it might be. But if it's a bank document and if the law doesn't say you can't do it, I can imagine at least a theoretical situation which you can construct to enable you to do it, but the risks are just not worth it in my view.
What do you think, Bob?
There are two facts here which would cause me alarm. One is it's the bank giving your friend advice that this is the way it should go. And the second is that there's a need to have the documents back in 4 days. Mm-hmm. Well, surely within a 4-day period there'd be better ways of doing it than via Skype. That's the first issue. But the second thing is I wouldn't be accepting the advice of the bank as to which is the preferred model, and I agree entirely with the other members of the panel here. I would advise against it, quite apart from the identity issue.
Well, we're getting tougher on identity. I noticed the other day, seeing that we're going to amend the Transfer of Land Act in Victoria to require stricter identity for mortgagees, requiring stricter identity. And I think New South Wales have always been a bit stricter than us on these things about checking identity. And I think technology's brought us Skype, which is great. It's also brought us identity theft and fraudulent documents being witnessed and signed by people who aren't who they purport to be. And I guess the other thing is too, Nahum was talking about instincts. The other issue of this scenario that we haven't really focused on is the fact that it's a friend asking you to do this.
Yes.
Now my antenna goes up a little bit there, because I think, well, unless these people live in the middle of the desert, why would they even need me to do this? Am I relaxing my usual careful standards to do a favour for a friend? And that's one of the very risky areas of helping friends and family, that you may be tempted to lower your guard and to do something you wouldn't otherwise do. And that's the additional angle on this, I think.
Mm. Well, I think that's right. And when we're doing our face-to-face ethics seminars, I will often ask practitioners for a show of hands as to what they would do in these circumstances. I mean, who would not do this? And almost universally, most hands in the room shoot straight up. They really do. And that's the advice we're giving the people who call us. Look, the law mightn't stop you doing it, but we think there are very, very dangers in this space, and we don't think you should go there under any circumstances. So I think we're all agreed on that. So Fred is acting for 6 directors of Great Finance Tips Proprietary Limited, which we'll call GFT, a financial services advisor, in a class action in the federal court brought by 563 investors in a failed investment scheme promoted and marketed by GFT. The plaintiffs have sued GFT and each of its 6 directors. Fred is acting for all defendants. The plaintiffs are alleging that GFT and its directors engaged in false and misleading conduct in relation to the potential benefits and possible risks of the scheme when it was being promoted and marketed, and that they have thereby suffered financial losses running to millions of dollars. GFT and its directors deny the plaintiffs' allegations and are vigorously defending the action. At the outset, Fred instructed senior counsel to advise on whether he could act for all 6 GFT directors as well as GFT itself. Following a conference with the 6 directors, senior counsel advised that their interests and those of GFT were identical and that Fred could act for all defendants. Following extensive discovery in the action, it has become apparent that the interests of 2 of the directors may be different from the other 4 directors, given certain letters which the 2 directors wrote to potential investors. Question was, what should Fred do? So Nicole, right up your alley. Commercial litigation.
As is so often the case with conflicts of interest, it seems like a good idea at the time, and ultimately it doesn't turn out that way. I mean, the short point is I think Fred is now in a situation where he cannot act for any of these parties. The difficulty would be, there might be a suggestion just teasing out the ideas that the parties might consent to him continuing to act for all of them. I personally think that's impossible in this scenario, because I can so readily envisage a scenario where the allegations the company might wish to make against the directors and vice versa can't be sustained on the basis of a jointly retained solicitor. So I think really Fred here he's rolled the dice. There probably wasn't anything problematic about him doing that, but it was inherently risky on one view, and that it's now come home to roost and he's now going to need to step back from it. Unlike our initial scenario where there was some doubt about the person not being a former client, here these directors obviously were his clients. He could not then take up the cudgels against them, and I don't think that there's any really 2 views about that.
Danny, this would be a classic one for us to see in the Ethics Committee, wouldn't it? How would you be approaching it there?
I think the mistake, I'm going strictly on the facts as given, that was made was not necessarily agreeing to act. It was not, by the sound of it, advising those clients at the outset that they need to make a choice before engaging him as to whether to engage him or not, on the basis that things might arise during the course of this case, and he would say, I don't know what they might be, but things could arise that could cause me to have a conflict, in which case you'd all have to go off and get separate representation, which is extra expense to you. Now, I can say that with the benefit of having seen that occur and having had advice from senior counsel before an action who advised to do that very thing, and then the client can make the clients can make an informed choice at the outset as to whether they roll the dice, not the practitioner, about whether they engage that lawyer or whether they go off and get separate legal representation early on. Now, if they then say, no, we're willing to take the chance that we might get sent off elsewhere later on, my view is, provided that lawyer keeps a very close eye on potential conflict issues, and it's not easy, but provided they do it, I don't think the lawyer's done anything wrong.
Isn't life hard enough? I just wonder whether that introduces an element of complexity. That why would one take that on?
I'll say, in answer to that, I would say because in a lot of cases, the amount of money involved would not justify 6 sets of lawyers. It might be a smaller company arguing about $100,000. To have 6 different sets of lawyers, 7 if you count the other party, arguing over that, I think the lawyers would then be at risk of getting a rap over the knuckles from the court under the current legislation about keeping costs proportionate.
Nahum, how do you feel this one works out?
Well, I think what Nicole said about it seemed like a good idea at the time is an attractive proposition. I think in a strict sense, acting for more than one party, you really need to be very careful at the best of times. You've got to start with the proposition things can go wrong. We all know how often litigation goes off on a path that was completely unpredicted. However, I think what Danny had to say, particularly about the practicalities of it and the fact that you might be fighting over a very small amount of money, and then the question, if you succeed, whether you get 6 sets of costs is another issue. Perhaps if it is a small amount of money, then the practical way to go is to accept counsel's advice but keep a very tight rein on it, as Danny has said. I think if there's a substantial amount of money involved, you'd need a good reason to act for more than one. So as a general rule, just be extraordinarily careful about acting for more than one person.
I guess, Nahum, particularly here where you have an adversarial context, it's not as though you're acting for the more than a conveyancing deal or in something that's more administrative in its nature. You have something here which is quite adversarial from the beginning. You have a litigation process happening. I think that might add that extra layer of alertness to say, well, maybe I shouldn't be doing that.
This situation arises in family law from time to time, where you get the same lawyers wanting to act for, say, the husband and his parents in a property case, and it sometimes happens that their interests diverge to the extent that simply can't go on. It makes for extraordinary complications, particularly if it happens on day 3 or 4 of a trial, and that's why you've got to be so careful.
Well, as here, they've thrown away the costs, I guess, now, because money's been spent coming this far, which need to be spent again.
Bob, the challenge of multiple defendants is something that arises from time to time in the criminal jurisdiction as well, doesn't it? So again, you've no doubt had to grapple with that issue from time to time over your years of experience in the criminal law, but applying those principles to this one, what thoughts have you got to offer here?
Rule 8 says that if the interests of the 2 directors as against the 4, if they're different, then you clearly have a conflict of interest arising. Now, I don't want to be seen to be picking up the adjudicator here, Michael, but did you actually read out the fact that the 2 directors had actually written those letters?
Bob, I was saving that.
I realise that.
I was saving that.
Thank
that,
you.
that
I
little
won't
morsel
address
of
it then.
information.
I won't address it then.
Let's go straight to it.
He's just
Can I
changed,
just, before
he's
you
just
do-
changed his name
He's
to Jeffrey
approaching
Robertson. I think that's the reality.
Well, so can I just say something else?
Please.
This is not an uncommon situation that arises where a number of directors get Section 19 summonses under the corporations legislation to attend for compulsory examinations. And we've had situations, a number of them, where we would act on behalf of a number of people. Then, at a later point in time, the authorities launch criminal proceedings or or quasi-criminal proceedings in the Supreme Court, and the question arises, can we act for all of them? And that situation's just arisen in the last couple of months, where 7 or 8 years ago we acted for 6 who were up before ASIC under Section 19. The proceedings were taken against only 2 of them, and one of the other 4 who weren't proceeded against, his name now appears on the prosecution list of witnesses to give evidence in the Supreme Court against these remaining 2. And he rang us about 4 weeks ago and said, can you act on my behalf or give me advice on what I should be doing? And I, quick as a flash, said, no, I suggest you get some other advice. You are now a prosecution witness. He had some difficulty with that.
In understanding that.
Absolutely. Even though the evidence that he was likely to be given wasn't significant, I'll say, in characterising it, wasn't significant against the remaining two defendants. Nevertheless, whether it was significant or not, he was a prosecution witness essentially, and we couldn't act in those circumstances.
He was on the other side of the fence. Yeah.
So this unfolding scenario, you see it happen a bit.
Of course, this raises that other issue which arises from time to time in these situations of the risk of having to cross-examine your former client.
Indeed.
That's an intolerable situation, if only because of those getting to know you factors that we referred to earlier.
All right, the little morsel that I was just saving up to then toss into the ring, and I suspect that I probably didn't need to, but if the added facts were added here, remember two of the directors wrote to potential investors about this. If you were told that those directors wrote that letter after receiving legal advice from one of Fred's partners and significant legal costs generally have been incurred, would that sort of alter anything you've said here? Anyone?
That'd either be a dissolution of partnership or a withdrawal from acting on behalf of anyone.
Danny?
I agree.
Nicole?
Just makes a clear situation that much clearer, as they'd say on X Factor. For me, it's a no. Definitely wouldn't be acting in that situation. I mean, the conduct rules provide for that.
Sure. And Danny, were you going to say something else?
I was just going to say, it's on the same theme, one of the most honourable things I've seen done in our profession was, I was referred a matter a few years ago by a lawyer who thought there was a small chance that he might have messed something up, a very small chance. As it turned out, nothing flowed from it, but he felt he had a conflict because someone should be advising that client of their rights potentially against him. I think it would have been very tempting for a lot of lawyers just to hope that it all turned out, but this person did the honourable thing and sent them off for some independent advice.
Good. Okay, well, I think that this was a really interesting discussion, and as everyone has said, it seemed like a good idea at the time, but beware, there were actually big danger signs sitting in the background that perhaps weren't seen as clearly as they could have been seen by the solicitor concerned. But again, we're in the conflict of interest area. One always has to be very, very careful indeed and, you know, really err on the side of caution at all times. So in this case, Fred has acted for John for some time in a very hard-fought and traumatic family court case. In a previous contested case, John's application to spend time with the very young children of the marriage was dismissed. The primary reason for that outcome was John's serious family violence towards his former wife and his ongoing great antagonism towards her. Fred's now at the door of the court in contested property proceedings between John and his former wife. The main item of property is the former matrimonial home. Fred realises that it would be contrary to John's interest to allow him to give evidence, as he would do great harm to his case and end up with what John would regard as another terrible result. Accordingly, the imperative strategy is to settle. Fred has lengthy negotiations with his opponent and receives what he regards as a very good offer to settle. The wife obviously wants to be rid of John and is prepared to pay a premium to achieve that outcome. Fred advises John that he should accept the offer and informs him that if he instructs him to reject it, he, Fred, would require John to sign to his confirmation of those instructions in a document which Fred would prepare. John is extremely angry with the whole situation and says to Fred in highly confrontational and threatening language, quote, "I don't care. She can have the whole lot as far as I'm concerned. I'm going to burn down the house and make sure that that blank and the children are in it at the time," unquote. Fred makes an assessment of John that he's serious in that threat. What should he do?
Well, look, I'm leaving aside the family law context because I'm not a family lawyer. It seems pretty clear to me that that person believes that that threat is real and they need to report it to prevent any harm coming to those people, is my view.
Okay. All right, Bob.
Yes, if this was a genuine concern in the sense that you thought that the client was really capable and motivated to burn the house down and do damage to the children and the wife, you've got to take it seriously. If he is a real lunatic, then you'd hardly run off to the police force and report him because you might have some fears about your own safety. So, and this raises the sort of situation that can sometimes arise, and fortunately hasn't arisen in my career very often, where you have someone in the office who's genuinely aggrieved about someone else, and they make a threat, and you think this person is deranged, and I've got to take this seriously, and they're threatening. You know, I had one many years ago, 5 years ago, where this gentleman in my office actually said, "I'm going to kill X."
Mm-hmm.
And I had to make a judgment about whether I report him to the police or not.
Mm.
In the end, I didn't, but I've got to say it was a complete gamble.
Sure, and you're very worried that you might get the phone call the next day that gave you the news. You know?
Precisely.
So it's very stressful for the solicitor, isn't it, in
Precisely,
those
yeah.
circumstances? All right, Nicole, what do you feel
I
about
think
this?
this really draws out the tension between the technical answer, which is that it is an exception to your duty of confidentiality to a client if you are breaching confidentiality to prevent commission of a serious crime or offence, looking at it that way, but also looking at, well, you need to assess, is this a serious threat? I'm sure that, as Nahum will testify, in most family cases you're going to get people saying foolish things, saying angry things on the spur of the moment, and I suppose you don't want to be in a situation where you're constantly running off to the police or to the other side. You would really need to be of the opinion that this is a very serious and credible threat. On this occasion I would say that it is, and I guess as a person as well as a lawyer, which we all are, I wouldn't want to be on the other side of being wrong. So if God forbid he should go off and do this and I've elected to say nothing or to not go to the police, would I feel a sense of moral responsibility? And these are all questions that these are probably the most difficult questions, and one of the reasons a lot of people do steer away from family law, because it does raise these emotional issues.
We haven't really addressed on what would you do in these circumstances, though.
I would absolutely go to the other side, and I'll give Nahum the right of reply here, but I would definitely consider going to the police. That's definitely something I would seriously consider, and I know Nahum has a different view on that. I don't think the information is privileged. I think it falls within the exception of furtherance of a crime, clearly being uttered in furtherance of a crime. I would be prepared to defend that and go to the police and take the flak.
I wouldn't go to the police in this factual scenario, but I certainly would discreetly approach the other side.
Well, Nahum, back to you.
Well, Bob wins the prize. This is, again, an instance when I was at the bar, and it happened somewhere between 25 and 30 years ago. So the law as it was then is somewhat different. I think today going to the police is a more realistic alternative than it was at the time. The information is clearly privileged and confidential, and the question is whether there is an exception. My reference earlier to the added duty which family law brings with it, that being the duty to the child as well as to the court and your client and your opponent and others, and of course primary to the law, to obey the law, adds that further extra thing. And there is no question, and 21 years as a judge of the family court taught me nothing if not this, that one doesn't want to wake up and hear the news the following morning as to some tragedy which has occurred. So I made the decision that I clearly could not do nothing. I clearly had to do something. What to do, the options seemed to be either the police or the other side. There really wasn't another option. The option of going to the police seemed to me to be hazardous, in that, firstly, clearly my credit against my former clients in that situation would open up all sorts of other things. Secondly, he could easily say, oh yes, it was just a throwaway line. However, as I say, I couldn't sit there and do nothing. I was extremely fortunate that I was opposed to somebody first who was extremely experienced in family law, and secondly who I trusted. So I went to him and I said, look, I can't give you any details, but just, you know, my fellow's history, and I presume your client's not living in the house, and perhaps she shouldn't for the time being, and perhaps it's also a good idea. You probably got it insured, but if you haven't, that might be a good idea. Now, that was as good a code as you could possibly use, it seemed to me, without my specifically saying it. And of course, you need to remember in this scenario that there was a long history of violence, a long history of extreme antagonism towards the wife. He wasn't seeing the children, so all of those things were really very relevant, and an experienced practitioner, as I was opposed to, didn't really need much analysis to work out precisely what was going on. So that was the. But I appreciate what Nicole says, that going to the police is a real alternative. I think more so today than it was 30 years ago.
And of course, you can't go to the wife. To draw that out of the
precisely
as well, you can't go to a representative.
And you
party.
mentioned that's an oldish case, an oldish example. But in the current culture that we have with family violence, intervention orders, safety notices and the like, it would be easier to go to the police about something like that.
Yeah. Let me say that as well as not going to the wife, you can't go to the court either. You can't tell the court. That would be a breach of your duty, as much as that seems to be wrong and seems as a matter of principle to be contrary to what is in the interest particularly of the wife and the child. But,
what would you have done, Nahum, if he didn't get it? If your opposing counsel didn't get it? If you felt that having issued that warning he wasn't getting it? I mean, you were lucky, you say you were opposed to somebody who was sufficiently switched on to understand the warning. What would you do then?
I think my next step would have been the Ethics Committee to get a ruling at the bar, and I don't know what I would have done from there. What I actually did, I did without feeling the need to go to the Ethics Committee, but I think if I remained as concerned as that, I think the next step is the Ethics Committee.
Did you continue to act for him?
We settled. He in fact accepted the offer very shortly after this event. I had him all signed up. I had my solicitor there. My solicitor knew what had been said, and I made it. And I signed my client up to the advice that I'd given him. I took all of those sort of all of those precautions. But of course, had the matter not settled and was actually going to go on, the next step was I was going to have to consider withdrawing altogether.
Fred is acting in a difficult commercial matter and does not trust the other side's solicitor Henry. Fred is worried that Henry will misrepresent what is said in their conversations, so Fred decides to secretly record all of his conversations with Henry in order to protect himself. The question is Fred's conduct ethical? Bob, what do you think about this one?
The short answer, and you don't want the short answer here because we want to tease out the facts and the other possibilities, but I say that it is ethical. It's not a practice that I personally adopt very often, but on one or two occasions I have had to record a conversation without telling the client that I was recording the conversation, and I did it for my own protection. And the recording device was separate from my telephone, and therefore there was no breach of the Telecommunications Interception Act, and therefore what I did was legal and ethical. In this particular situation, I say that this is ethical, that's my opinion, and it's certainly legal.
All right, Danny, what do you think as a member of the Ethics Committee?
It may be ethical. I'm not convinced it is. It may be, but I don't like it, and I think it goes against the grain of a profession. And we're talking an example about practitioner recording practitioner. Is it? That's
Yes.
right, just so I'm not confusing myself. And I must admit, it only came to my attention some months ago that apparently it's a reasonably widespread practice within the profession, and I was staggered.
I'm staggered.
I'd never considered doing it. I would be highly offended If I found out someone was doing it to me, I don't see why, if things had reached the point where they felt they needed such a record of a conversation, why they wouldn't just say, can we keep the communications in writing? I wouldn't be offended about that, because at least I would know. Often in conversations, in commercial negotiations, you want to be able to speak off the record, in the sense of speaking freely without being particularly guarded in your words, to progress the interest of your client and the negotiation. I think that if this is becoming more widespread, people are just going to resort to written communications, or telephone calls, which used to resolve matters, will now be less likely to do so.
No, what do you think about it?
I feel very uncomfortable about it. I'm prepared to accept that it's legal. I start on that basis. I feel uncomfortable about it ethically, and the basis of that is your fiduciary duty to the client, and which is a very high duty, and the question about whether your client is entitled, pursuant to that fiduciary duty, to know everything that you are doing. I think in practical terms, in acting for him, that is, I think in practical terms, I agree with the proposition. If your relationship with your client has got to the stage where you feel you have to surreptitiously record telephone conversations, then the question has to be asked whether you can trust yourself to continue to act sufficiently professionally, or professionally, not even sufficiently, in order to properly represent your client. And that I think is really important. To my mind, if you're going to record your client, it would be just as well to say to your client, look, we've had some problems in the past, we haven't agreed on all of these things, I'm proposing to record what it is, and if the client doesn't like it, then you stop acting, and it seems to me that is more out in the open. So my instincts tell me that's the better way to go.
Well, interestingly, Nahum, in that situation that you postulate of recording your own client as distinct from some third party, I have to call the solicitor back tomorrow to discuss that very issue,
yes,
where what he has done, as I understand it, is taken the step of putting that in writing to the client right at the start, that
yes,
it is my practice to record all conversations,
yes,
and so that's kind of giving general notice of that, and he makes it out that he doesn't use those tape recordings other than for the purposes of having an accurate record of what is said. I suppose if it's up front and you're doing it, it's the same as with Danny, you say to the other solicitor, in that instance we're attempting to record the other solicitor, well look, I'm sorry, we've just reached a point where I can't trust you anymore, and I hope you're not offended by that, but we either have to do all of our communications in writing, or you agree to me recording and I'll happily provide you with a copy of the tape. You know, that kind of situation where it's done above board and out in the open.
I can remember being in situations as a practitioner where my trust of my opponent had broken down, and I said, I'm only prepared to deal with you in writing.
I don't have a problem with that, but I actually do find it quite offensive to the sort of traditionally high standards of fairness and candour and fair play with your opponent to do this now. With the greatest of respect to Bob, and I don't know the circumstances, there may be exceptional circumstances where you need to do it to protect your legal interests, but if we're doing it routinely, if people are doing this routinely, I really despair for what it says about us as a profession. I mean, there's nothing in the conduct rules that specifically prohibits it, but I've always regarded the conduct rules as a sort of minimum standard or a starting point. I think at the end of the day, if what you're doing, albeit there's nothing in the conduct rules, if what you are doing damages the profession, the reputation of the profession, and lowers public confidence in the system, does it make lawyers look disreputable to the public? Yeah. I absolutely think that it does. And in all but the most exceptional circumstances, it would grieve me to think that we as a profession have reached a point that we are doing it routinely, as opposed to doing it for a very good reason, if there is some issue in a particular case. You know, that's what I think makes us a profession, that we do trust and rely on one another as professionals.
Nicole, what you've raised is a very interesting issue when you talk about the reason for you doing it. Does purpose make a difference here? If it's, quote, a good purpose, does that make it good? Let me give you an example. I delivered this scenario in a seminar a few months ago, and a lawyer in the firm told me that he acted for a number of major construction companies, and that from time to time he had received threatening telephone calls from members of trade unions. And he said, I would like to have a situation where I've got a record of those, so that if anything ever happened to me or my property or my family, there would be some evidence sitting out there to support a complaint being made to the police. And that, on the face of it, seemed to be a kind of a worthy purpose. So I'm just interested in teasing out that issue. Does the nature of the purpose have anything to do with it? Bob, what do you think?
Could I contribute 2 points?
Sure.
I agree it would be a great shame if this became routine throughout the profession. I have never had to tape record a lawyer, never. The instance I was talking about before, for the purposes of the audience, perhaps I should briefly mention the factual scenario. A client rings me from a jail in New South Wales, gives me instructions to go along to the county court and tell the judge that he wants to plead guilty to thefts involving $12 million. I had 2 conversations with him where he expressly gave me instructions to go along to the court and plead guilty. All the to's and fro's, the pros and cons of it were explained to him on the lengthy telephone conversations. I went along to the judge. I told the judge he wanted to plead guilty when he was coming back after completing a 6-month sentence. When he came back, he sacked me, went to the judge and said he wanted to reverse his plea, and the judge called me in and wanted an explanation as to how I came to advise the court that he had given me instructions that he wanted to plead guilty. I was cross-examined by the client from the dock. He had no lawyer. He asked me if I had any notes of the conversations. I said I did. He said, do you have the paperwork there? And I said, it's not in the form of paperwork. He said, what are you talking about? I said, they're tape recordings. And he sat down in the dock, stunned. The judge asked me, did I have them on me? And I said, yes, I do. He said, do you have any objection to handing over those tape recordings? I said, not at all. He said, could we also have a transcript made of those? I said, they're the court's. Handed them over, and clear as a bell on those long conversations, the client was indicating he wanted to plead guilty, knew exactly why he was pleading guilty, knew the pros and cons of that, and I did it because I had an instinct that this particular individual was dishonest, and I was doing it for my own protection, and I'm glad I did. Well, it doesn't happen very
often.
That's
more practitioner to third party. I guess I draw a distinction for purpose in answering your question, Michael, but I also draw a distinction between recording somebody else, be it a client or a third party, and another practitioner. My comments were really aimed primarily at practitioners recording other practitioners. I can certainly see cases where you...
My response was a response to what Bob had first said. I'm not quite sure why another option at that point might not have been to say to your client in jail, look, this is really important stuff, I need to record this so that I've got it, and that would have avoided the question that you had.
I probably could have done that.
Yes, yeah. I'm not being critical. I can well understand we've all acted for people. We've at times signed people up to their instructions and got them independently, witnessed, and all of those sort of things. And of course, in family law, that is particularly pertinent, and in crime as well.
Okay, well, what an interesting discussion. And all we can say, I think, in this space is watch this space, because it is still under active consideration by the Ethics Committee, and we look as though we may be moving towards developing a guideline for the assistance of practitioners. As you know, we have about 20 guidelines up there that practitioners find very helpful, that the Ethics Committee has produced and which are then published on the authority of the council. So watch this space. I think we'll be seeing more about it in the not too distant future.
Michael, forgive me, can I just go back to something Nicole said, because
Of course.
I think it really is at the heart. This profession operates and has to operate on the basis of trust. And the point at which that trust breaks down is the point at which the profession breaks down.
Correct.
I know, as both a practitioner and as a judge, there were people I didn't trust. There were people who I could not rely on to tell me what the actual situation was. And I think the whole aspect of lawyers' ethics relies on that one point. That is that the whole thing operates on the basis that we are a profession, and part of being a profession is that trust factor. It's a fundamental part of the profession, and we must never lose sight of that, it seems to me.
I agree entirely.
Yeah.
Thank you very much, Nahum. I think that sums up that point perfectly, and I hope we all listen and take account of that, because I agree with you. It's the bedrock of our profession. One day at a family barbecue, your mother-in-law tells you that she's very worried as she and her husband are being audited by the Australian Tax Office. They own an investment unit, and the ATO are questioning the validity of deductions claimed for renovations to the unit. She is very concerned about the stress on her husband, as he has a serious heart condition. She can't tell you much more, as she has always left all the finances and joint tax returns to him, but she begs you to help them, saying, "It's times like these I thank heavens we have a lawyer in the family. If anyone can sort this out for us, you can." When she walks away, her husband confides in you that when the deductions were claimed, the woman renting the unit was an arm's length tenant. Sometime later, however, he began a relationship with her, and since then spends significant time there, and she no longer pays rent. You are shocked and know this would utterly devastate both your mother-in-law and your spouse and cause huge fallout within the family. The ATO have offered a deal to settle the matter, which would involve your father-in-law making a large payment from his and his wife's joint account. You believe that if he challenged the matter, he would have a very good chance of success, but it's highly likely that his extramarital relationship would be exposed. Your spouse is also very worried about the effect of all this stress on their beloved father and pleads with you to do what can you do to help. Well, what should you do? Danny?
Stay well out of it. Absolutely. Families approaching for legal advice. I was advised by a very experienced lawyer when I was starting out. Generally speaking, stay away from it. It gets complicated, and that's to me is a fairly clear case of saying, look, there's relationships between us here. It's not appropriate. You need arm's length advice. You need independent advice. That would be my out, to stay away from it. The biggest problem, it seems to me, in acting in family relationships is you lose the degree of objectivity, which comes out of that scenario. Worrying about all sorts of other factors, relationships and so on, rather than looking clearly at a set of facts, giving the best legal advice you can. I just don't think that person's in a position to give that advice, and they'd be doing a disservice to themselves and the clients by trying to act or give any advice, even informal.
And here you've got the problem of who's the client, because you've got mother-in-law who's come along and told you certain things and asked for advice, and then the father has come along and given you highly confidential information. So if you treated them as two separate clients or even as joint clients, you're already in a conflict situation because of the information you've received.
She said, if anyone can sort this out for us, you can. Now, Al Pacino has a fantastic line in Scent of a Woman where he says, watch the us part. So I guess it's really a question of that conflict, conflict on the facts. Bob, sorry.
Well, I was titillated by this factual scenario, and I thrashed it around with my wife. And the more we got into it, and the more we thought about how it would unfold if you tried to act on their behalf, the worse it got. It would be a complete mess, and conflict is spelt with capitals.
Conflict not just in who you act for, but conflict with your own personal interest. Because you want this to go away.
Absolutely.
You don't want this family fallout, so you might be inclined to say to father-in-law, take the deal. But as a lawyer at arm's length, you would never say that. You would say, look, if these deductions were claimed at a time when this was an arm's length tenant, then you should push ahead with it. So there's that immediate conflict which comes out of it as well. The other obvious thing is, are you even a tax lawyer? The problem sometimes with acting for friends and family is that they think that as a lawyer, you are an expert in every possible area of the law. And wanting to help them, obviously, and wanting to sort of be the hero in a sense, there's that temptation to offer advice in areas that you don't specialise in, and I guess known as dabbling, to try to provide advice on everything, and that comes out of this problem as well. An easy out would be to say, you need a tax lawyer and I'm not that. The other thing, I suppose, is the veracity of the father-in-law's evidence. He has said to you these deductions were made at a time prior to the relationship beginning. If that was an arm's length client, you would check that. Are you going to check it? when it's your beloved father-in-law?
Yeah.
And most boringly, I suppose, what does your practicing certificate say about these sorts of matters as well? If it's not a principal practicing certificate, then you probably shouldn't be doing it just on that basis alone.
I just want to put a spanner into the works here.
Okay.
Is there a lawyer-client relationship in the first place?
Well,
I very strongly doubt. This has happened at a barbecue. With all the, it reminds you of the slap, doesn't it?
well, tease it out. Say the wife says, "Why won't you act? What's the situation that's bothering you? You look very pale. You know, you heard this information. You look upset. Are you going to tell her? Can you tell her?"
Well, if there's no lawyer-client relationship, yes, of course you can tell her. There's no confidentiality. Then it's that classic situation that I suspect we all find from time to time, is where you know some information about friends or family that would hurt other members of the family. Do you disclose it? But that's not a legal ethical problem. That's a personal problem which you've got to deal with as you see as being appropriate. My view is this has happened at a barbecue. I think the one mistake that was made was, and I think Danny's right, I think in response to Michael's question, what should you do? You put your running shoes on and you run as fast and as far as you possibly can away from this situation. You simply say, look, your family, I can't possibly do anything about it. And that would have stymied getting the embarrassing information, whether as a lawyer or privately. It seems to me it might have got you out of a whole lot of trouble at that point. But as a matter of principle, simply do not act for family and friends. And if you follow that rule, then you can't go far wrong.
What you say is right, though, about shutting that conversation down right from the get-go.
Yes.
And it's difficult sometimes because you get caught on the hop in a social situation. You may have had a few at the pub. I mean, these things come up in situations where you aren't thinking as defensively as perhaps you should, to sort of stop people and say, listen, it's not appropriate that you tell me this. I really don't think it's appropriate to hear it. It's easy to say looking back on this because this information has come out, but it's a very difficult thing with family and friends who may think, well, we've supported you throughout your education, we've been there for you, and the minute we need some advice, you run for the hills.
There were no formal instructions given.
No.
The words were used, if anyone can sort this out for us, you can. It was a casual engagement.
In which you say, well, no, I can't. But we ran this kind of scenario in our ethics seminars a couple of years ago, and I used to open it by saying, well, the question is, we're often asked over the advice line, is it unethical to act for family and friends? Quite a common call. And my normal answer to it is no, but why would you want to? And then work through the issues. And Danny, the independence, objectivity, I think is a big issue. The practical issues are the family will want you to act for them for nothing. Your friends will want you to act for them at mates' rates. They'll think it's okay to discuss their affairs between the Sunday lunch and the Sunday dessert when you have no opportunity to have a confidential conversation with your client, take appropriate diary notes, send appropriate advice to them, that kind of stuff. And then, they ring at 3 a.m. when they're lying awake worrying about their difficult family law matter and would like you to chat to them for the next hour, sort of helping them get through this difficult night. So there are lots of very, very practical reasons, I think, why you just wouldn't want to touch it with a barge pole.
Well,
I think
not to talk about the added issue that you might break up your marriage as well.
Absolutely,
From
exactly.
a common sense point of view, that's absolutely right, though, because unlike other clients, you have to live with these people afterwards.
Yes.
And from some of the cases I've looked at on this, family and friends are even more unforgiving when things go wrong than strangers, often because rather than give you specific instructions, they think they've given you a general mandate to act in their best interests and do as you think proper. And you may even go ahead and do that. And that's where it becomes very, very dangerous.
Michael, can I just add a practical tip?
Please, Danny.
I know one of the lawyers at my firm uses, and it picks up on something you mentioned. She was telling me the other day that she had a scenario, a family barbecue type scenario, and that she uses the line about the insurance and just say, look, I'd love to help you, but I'm not insured giving advice like this, so I'm not going to give advice because it's no good for you to have an uninsured lawyer, and it's certainly no good for me to be uninsured giving advice. And just cut down like that, which I thought was quite clever.
The other thing people don't think of is privilege. Some people will actually say to me, in that scenario, I make it very clear to them that I'm not giving them legal advice, I'm simply helping them as a friend. Well, that's great, but it probably means privilege won't attach because you're not giving them advice in a legal capacity. So you may actually be doing more harm than good to their case.
But if you do say anything like that, the risk is that they go away tomorrow and say, oh, I spoke to such and such, sat next to them at dinner last night, and they said such and such, and that's what we're going to do. It's fraught with risk.
Absolutely.
To just underscore the potential for the risk here and how badly it can go wrong, just beware social media, and in particular Facebook, where we are seeing situations like this where these kinds of informal requests are being made by Facebook friends. And remember that whatever goes into Facebook is going to be there for the next 1,000 years, so it'll be very permanently recorded, and the difficulties of really setting up an unintended solicitor-client relationship in that space can't be underestimated. So again, to those practitioners who are watching who are regular users of social media and Facebook, be very careful in this space. And a couple of years ago, the Law Institute published ethical guidelines regarding the use of social media. We were the third law society in the world to do so, and I get continual feedback from practitioners to say how useful and helpful those guidelines have been. Well, I think we've reached the end of a very, very interesting panel discussion and debate about ethics. So I would like at the outset to very much thank our four panellists, Danny, Nicole, Nahum and Bob. The Institute is very, very grateful to these practitioners for the time and effort and enthusiasm they have put into this project. So thank you very much, Nicole and gentlemen, and it's been a pleasure working with you, working up to today, and I hope we can do it again.